Good morning, everyone. Thank you for joining our live Zoom webinar with me and Daniella Mair. Today's topic, family mediation and parenting plans. Daniella spoke to me yesterday and she told me, Mohammed Advocate, we need to deal with a serious issue concerning parenting plans not being agreed to or implemented or trying to draft one um, at the start before problems arise. So to welcome Daniela, thank you for joining again. And I love you. You're very spunky. You're very fast. I get very good reviews from you from many other people. People watch his videos. They say she's awake. She knows what she's talking about. How are you doing? How are you doing, Daniela?
Thank you very much. I'm doing very well. I'm a little bit irritated today, but that's why we're doing this, and we're going to get down to business and deal with a couple of things that are really causing a lot of problems. But other than that, all good.
Daniela, thank you very much. Wonderful. Let's get down to business. What problems have you been experiencing with parenting plans not working or not implemented or not working towards having a parenting plan in place?
So I think I want to start by telling everybody that you have got as much power in all of this as you're allowing yourself to have. What I mean by that is that you do not have to sit back and be a victim. You don't just sit back and allow things to happen that you've never considered or that you don't know how to change if you just know what to do from the beginning. So I don't know, in terms of viewers, we may have some viewers now that have got existing parenting plans. We may have some that have gone through divorce, who want to go through divorce. We may even have some people who are still waiting to start a family, whatever the story is. The point is that I cannot tell you how important having a parenting plan in place is for any situation. And really, you've got the power to get this done. So I'm going to give you an example of why this can be so important. I have been getting so many phone calls lately from people who are trying to change a situation that they're currently finding themselves in terms of parenting plans, sharing access, co-parenting, whatever the story is. And they literally are coming to me as a last resort to say, please help me. I can't have this anymore. We need to go into a new situation. Where do I start? And the first question that I always have to ask is, have you got a parenting plan in place? Is something court ordered and documented? And unfortunately, 9.5 times out of 10, the answer has been no. This is an extremely difficult situation to be in, not only for me, but for, the client or the parent as well, because it is absolutely a given that whenever there's any form of dispute, we go back to the court order. So what we do when there is no court order, and that's what I'm finding now to be a big problem. So I had somebody phone me the other day who says, listen, the mother has taken the kids, she won't give me access, she won't allow me to see them, I'm the father, what can I do? Go back to my first question, what does the court order say? No, we don't have one. Okay, well, what does your agreement say? Have you got a parenting plan? No, we don't. Now we're in a situation where the only way that we can come right is through the court. And that is a situation we don't want to have to go through every time there's a dispute. If we have a parenting plan and mom has taken the children and won't give them back to dad, and there's a court order that says dad gets them every second week, then we've got something to fall back on. Then we can phone the police and we can say, this person is in contempt of a court order, and we can quickly make an adjustment. We can get the police in to come and take and help remove the children. We can then go to courts having said, this person has been in contempt, this plan is clearly not working, and we can make amendments as necessary. But without that documentation saying who has got right or access to the children at that particular time, there is absolutely nothing that we can do to remedy it immediately. And again, unfortunately, in this kind of a situation, the only people that are going to suffer from it is the kids. Because imagine now, dad has kidnapped the kid, so to speak, pretend he doesn't have any access as part of a court order. Let's say he only has supervised access and he removes the children. Then, of course, the police can come in and we can say that he has taken the kids against the court order and we can get them back. Even in that kind of a situation, we've got children who are sitting there watching this all go down. So it is vital to remember that the children need to obviously be protected first and foremost, but the more that we have written down, signed, agreed, court ordered, even if it's not court ordered, if it's signed and agreed, then at least we have got legs to stand on when dispute come up. And I think what most people don't like to forecast is that an amicable situation could turn ugly at any moment in time. Any circumstance, anything can happen, and all of a sudden, this peaceful co-parenting situation becomes a disaster. If we've got nothing documented, nothing written down, then we have got a serious problem. So please, my advice for the day today, or for this webinar, is even if you think it's not necessary, just do it. Have everything documented, mediate it, whatever the story is. Let's make sure that both people are happy and comfortable with the arrangement while we're still amicable. And then if things come up in the future, then at least we've got a process to deal with it correctly.
Yeah, Daniella, my motto always is, it's unfortunate that your relationship with your spouse, your partner, whatever the case may be, hasn't worked out. You guys were unsuccessful where that is concerned, but you can still become the best co-parents to your minor child. You can become awesome parents. Your minor kids can say, Mom and Dad, your marriage didn't work out, or your relationship didn't work out, but you guys are the best parents I can ever ask for, even better than parents that are living together or married, etc. And that's important why we should have a parenting plan, and why they need to consult with persons like yourself to create a customized parenting plan working for their specific situation and circumstances. I mean, one parenting plan might deal with a situation where the kids live 2 minutes from either parent, and another parenting plan will deal with a situation where the parents live in different provinces or a few hours drive, or 5-year-old kids or 10-year-old kids.
Yeah.
So Daniella, that's what I love about you. You customize your parenting plan. It's workable and there's a solution in place. And when you mentioned earlier on about going to the police, unfortunately, what do you do? The child must be with the dad or the mom. The other parent is refusing contact. We can't just leave it and make a high court application or a contempt of court application, costs you hundreds of thousands of rands at the end of the day just to enforce contact. The police must come on board and enforce the order, but we want to avoid it as much as possible. And therefore, clause in the parenting plan, dispute resolution, etc. must be stated. But at the same time, parents have their own versions of a parenting plan. It is nothing written down on paper. The father has his version, his understanding. The mother has her version of this clouded parenting plan. They need to have it on paper.
100%. I mean, it's absolutely heartbreaking when I have situations where there's been a misunderstanding of the parenting arrangement and there is nothing documented. Then we have a situation where you may have one parent who has been the sole provider in terms of care for the child. The other parent comes in 3 years later and demands access. This poor child is now shipped off to somebody she doesn't really know. And there's no way to get the child back immediately. Then we're starting in the realm of the child's emotional well-being, their future emotional state, like how are they going to actually deal with this? The child could feel things like abandonment from the one parent for allowing this to happen. I mean, it's absolutely endless. And then on top of that, we also deal with certain types of people that while they have the child against the better judgment of everybody involved, that we start dealing with things like parental alienation, and they try and alienate the child from the other parent. And this can go on for months. I mean, you said high court application. I mean, that's the fastest way, and it costs a lot of money. But if we now have to wait for the court process, and we have to then go through the social working process and all of that, I mean, that's months and months. And in the meanwhile, there's no way that we can absolutely know that the child will be put back into the situation that he or she is accustomed to while it's going on. Because we don't have the right to say you can't have your child. Whatever the situation, without the parenting plan, without the discussions and court orders, both parents are the child's parents. And we can't now say mom is better than dad without doing the investigation. So in order to do the investigation, we have to set aside a good few months. It could be 3 months, it could be 4 months. What happens to the child in the meanwhile? Now we have this whole big battle between mom wants the child, dad wants the child. Nobody in this situation thinks about the child. Because if they did, they'd say, you know what, the child's used to being with the one parent for 3 whole years. I wasn't around. What kind of parent would now say it's best for the child to be with me? Obviously, the child must be with the other parent. But then it becomes this whole power struggle, and they're only willing to adjust their points of view with a recommendation from professionals, and that doesn't even go so well sometimes. And that is why the court then has to step in and say, I'm now ordering you to give the child back, and you will see the child every second weekend. Then it's final, and then it doesn't matter how you feel about it. That is the court order. But the process to get there is so lengthy that it's actually, it just doesn't make sense that you wouldn't have these things put in place before. I mean, you buy a car and you get a maintenance plan. You look ahead, years ahead, to see what is the best way for me to protect my asset now. And you put everything in place. Why don't we do that for kids? And I'm not saying kids are an asset, but why don't we do that? Why don't we forecast and say, well, what is the worst thing that can happen to my car is that I can get in an accident, it can be written off. This is what I'm going to do if that happens. And with a child, what is the worst thing that could happen? I won't be able to be there to emotionally support my child and to care for my child and to make sure my child's safe. If that is a situation, what are we going to do in its place? We don't do that. And that's the biggest pity out of all of it.
And Daniella, on the point concerning litigation, besides litigation being very expensive, it's highly complicated. It's not like somebody took money from you or knocked into your car. You go to court. The court gets an expert to quantify the damages. Quickly, simple, who's at fault. With child care matters, it's highly complicated. Here you're dealing with emotions of the kids, the child's best interest, the mother's view, the father's view, the court's view, the experts on board. So it can be this whole cluster of people dealing with this matter, and it can, at the end of the day, confuse everyone much more. And I pick that up sometimes, where one expert says one thing, the other expert says the other thing. And the other problem we have is, the other challenge we have is, if you take the matter to court, besides it could possibly take very long, because you go to court urgently, the matter gets postponed for experts to report, then the experts delay these matters. But there's a cost implication as well. If you lose the court case and you're unsuccessful, besides you having paid your own lawyer, your own legal team a lot of money, you might have to pay the other party's legal team as well, pay for their legal expenses as well. So if you spend 100,000 on your legal team, you might have to spend another 100,000 on another legal team. And the problem does not necessarily get resolved. You might be further away from resolving this matter because animosity gets, put into the picture.
Absolutely.
So my view on these matters is, don't litigate on childcare matters. There are many reasons when you should litigate, and I deal with those matters on a regular basis, urgent matters, social welfare issues, which I have to act very fast because mediation is out of the window. The mother or the father took the child out of nowhere, refuses to give the child back. The child is being, abandoned, neglected, etc. So of course, those are urgent matters. But when it comes to normal care and contact issues, parties were living together, they're separated, they're no longer living together. There are now contact and care issues. Dad wants to have the child, mother wants to have the child. Don't litigate on that. Go and mediate this issue as soon as possible.
Absolutely. I mean, that is why we're here, and that is why we move towards mediation, is because it is the only way. And I'm sorry, nothing against the legal system or litigation, but it is the only way we can attempt to give both parties what they want. The only way. In litigation, one is going to lose, one is going to win, and that's the end of the story. That's what it's there for. With mediation, there are so many aspects that we can negotiate that both people feel like winners or losers. And that is what we want. We want both parents in this situation to have the strength and the dignity that they feel that they can be a parent to their child and that they're not just cast aside or that they weren't out-lawyered, so to speak. It's your opportunity to be heard. It doesn't have to be a process where you're coming in to fight. We can have a situation where something might not be as important to mom as it is to dad, and mom might be happy to negotiate on that. That matters, then dad's won it, so to speak. And then the next issue might be the reverse, and then mom's won that issue, and everybody leaves there feeling like they've gotten what's important to them. And they don't need to fight over the little silly things that actually are not important to them. I've got a friend who, on Mother's Day, her biggest present is that dad comes to take the child away from her. She can relax. you know, and we sit here fighting about, I want the child on Mother's Day and Dad can have the child on Father's Day. When we sit down and we mediate it, we might find that that's not even what the mother wanted in the first place, you know, and the father's like, why should I give you the child on my day just because it's Mother's Day? That was completely like eradicated because of the fact that the mother had the opportunity to say, please take the child, that would be great, you know. And then there was complete conflict dissolved like immediately, and we wouldn't have even thought of that, you know. I mean, it's a stupid example, but it's something that's relevant.
Yeah, and Daniela, I always ask my clients these questions. You know, if you were the judge, and you had this magic wand or this pen that you can make any order, whatever order will you make? And that makes the client think now, you know, is what I'm requesting and what I'm requesting rational, logical, in the child's best interest? Or am I thinking with my ego, you know, with am I continuing a battle I had with the other parent while we were together or while we separated, or because the other parent had an affair or she moved on with her life, etc. Am I continuing that battle and using the child as a pawn or as a punching bag to pursue that battle? And that seems to be the case many times. So I warn people, do not necessarily fight when you can resolve the matter in a different manner. It's very important you do that, because at the end of the day, if this matter gets before a social worker, a psychologist, let's say, Daniela, you deal with a matter like this, you invest 10 hours in the matter. The judge in the high court, he reads through the documentation, he applies most probably say 5 hours on this application, and there's some argument, so let's say 10 hours as well. So third parties, the expert and the court applies 10 hours of their lives to a matter that will affect your entire life for the next 10 years. Let's say the kids are 8 years old. And who will be in a better position to make a decision? Not the judge and the expert having applied 20 hours in total. It will be you and your spouse that knows the kids, that have been living together so many years, that knows each other in and out, knows the circumstances much better, as opposed to getting a third party to deal with the matter. So Daniela, my question to you is, a couple, what type of couple should come generally see you? When do, I mean, there are scenarios where couples do not have to have a parenting plan because things just work out and they have an understanding. But at which point, what are the telltale signs or the things I must look out for the type of couples that must come see a professional like yourself?
So the first kind of couple, the most obvious one, is a couple that have decided to get divorced, that have already got a family, they've got the children, and they decide that they need to have a parenting plan in place so that they can separate. With divorce, you need to have a parenting plan annexed to a divorce order if you've got kids. So those people will come to me for mediation to get all the documents together. Some of them might have reasonable and working solutions, and we can just document that, put that down, and send it off to the lawyers. So that is the one type of person. The second type of client that I get is people who have now got issues and problems with existing parenting plans that they want amended. And that's also relatively simple. It's a little bit more conflictual, but they will come to me then with their documentation, and we'll look through it, and they'll say why this isn't working and how they want to change it. And then that can get mediated, and then amendments just get documented. And the third type of client that I get is the people that do not have anything in place, and they've just had enough of what's been going on, that they now 3-5 years down the line want to document something. Now that is what I'm talking about today, because that is the situation that is the most difficult to navigate. That is a situation that is most difficult to get both people to agree to come. So really, if you've got children and you've got an ex-spouse or an ex-partner, that you are the person that needs to be going to mediation or something like that. Like I said previously, is that it doesn't matter if you've got the greatest co-parenting situation. Everything might be absolutely like picture perfect, and then one of the parents get a new partner, and then everything changes, and it's not something that you've ever thought about. It's not something that's ever come up. You have no idea how the other party is going to react to it. So I would say that if you are in a situation where you have got an amicable agreement, everything's great, at very least, make sure you've got a parenting plan before you drop bombs on the other person, you know. This is for your children, to make sure that the children are taken care of, that you've got everything in place for them rather just do it. It's not, mediation is not something that's extensively costly. It doesn't take a lot of time, especially if you're in a good place. Then it's easy to agree on certain things. I have clients that come to me and I say, is he a good dad? Yes, the greatest. Is she a good mom? Yes, the greatest. Do you want the child to have equal access? Yes, absolutely. The more time, the better. And then literally within half an hour, we can just draft something and that's that, Because I'm telling you now, that same couple, once a bomb's gone off, that same couple are going to come back and say, you know what, I actually don't want my child spending too much time with dad. He's not a good influence. Why all of a sudden? It's now become personal, Now the kids have gone out the window. So first case scenario, best case scenario is before anything happens or changes, get your parenting plan drafted. Second situation that you'll be in is that you want your situation amended. And then the third one is where there's so much conflict that we've now got a problem, and now we're reacting. And now we need to get somebody involved and get something drafted. So those are the three kinds of situations. Rather try and get in on the ground floor and make sure that everything is done before the conflict arises.
Daniella, thank you for that. And also in terms of the Children's Act Section 33, it specifically stipulates that before approaching a court, the parties must try to mediate on a parenting plan. If they are experiencing difficulties regarding parental rights and responsibilities. So that's very important, because if you decide to go to court without first trying to resolve a parenting plan or enter into a parenting plan, and the court knows this, the court might have a hectic cost order against either of the parties, because it's a prerequisite in terms of Section 33 to first try to agree upon a parenting plan. Obviously, urgent matters, and there's also the exception that wouldn't apply. But if the mother or the father feels I want to have more contact, and they go to court immediately without first going to a professional person, a social worker, a family advocate, the psychologist, etc., whatever the access or suitably qualified person, they can have a very costly order against them for wasting the court's time by not following the procedure. Because had they gone to the parenting plan route, they could have possibly have resolved this matter out of court, saved everybody a lot of money, saved the court a lot of time, etc. But now they decided to come to court and they wasted everybody's time. So that's great. Daniella, how does the process start? You mentioned now what type of clients must come. Do they contact you? What do they do? Who contacts you? Because this is what we are going to. This is the husband has a problem, the father has an issue, the mother might have a problem because now he's the one that's contacting you. How do you deal with those type of issues?
So, the ways that I get contacted, there's three definite ways. The first one is that a couple decide to mediate, or one person decides to actively find a mediator. Then that person will contact me. Like you said, now it is very difficult, because as a mediator, my job is to be completely neutral, unbiased, non-judgmental, and all of that kind of stuff. And the second I speak to one person, the other person automatically feels that I've now built this rapport with that person. I'm therefore not a neutral party anymore. So if that kind of person does contact me, I will make sure that everything is transparent, and I'll say, please send me your email address, and I will send an email to that party as well as the other party. And I will write there, like, dear so-and-so, thank you for contacting me. As discussed telephonically, I cannot discuss anything with you without the other party present. Please, would you let me know if you'd like to continue with mediation or whatever the story is, and we can set up a time where we can meet and discuss the process. That way, the other party sees that I'm being forthcoming, that I have spoken to one, refuse to speak about anything specific, and I'm inviting both of them to come and discuss the process with me. So that's the first one. The second one is I get recommended, let's say, by one of the party's attorneys. That is slightly easier for both parties to accept, because it's not coming from the one side, it's coming from the representation. And usually it comes from the one legal party to the other. And when we're dealing with people who know the process and understand it as a profession, then they understand what the role of a mediator is. So lawyer A will send a letter to lawyer B saying, dear so-and-so, my client, whatever, we're recommending X person to mediate this matter, kindly advise, or whatever. And that lawyer will then go and give the information to his client, and will then say, you know what, this is a good idea. This person is a registered mediator, they're accredited, whatever. let's do it. And then the client will then say, okay, well, I trust you, you're my lawyer, and that's how that works. The third one is being court ordered or being appointed by the governing body like FAMAC or whoever you might be involved with. So, I mean, this is also more on the parenting coordination side, but I also get referrals from the FAMAC website where somebody has contacted them directly and said, I'm looking for a mediator, can you make recommendation? I'm in this area, I'd like a legal mediator or a psychological mediator, and they will then send a recommendation through. And then with that also, that party can then give it to the other side to say, I got this person from FAMAC, you know, not I've gone to seek this person out and have formed a relationship already with her or with him, deal with it. So those are the three ways that I get my clients. But there's one thing I just want to just jump in and say is that when you are in a process, whatever it might be, and this is like a cross life, but like let's let's zoom in on what we're actually talking about. When you have gone to a professional, be it a lawyer, be it a mediator, be it a parenting coordinator, whatever, they have trained for years and years to get to where they are and to become accredited and to become members of the bar or to be accredited with FAMAC or a health professional society, whatever the story is, just trust them. They are there to do their job and they know how to do their job. So if they tell you something you don't want to hear, it's time to now sit back and think about what it is that you want to hear and why you're unhappy with the truth, you know? So the point is, do not go from psychologist to psychologist waiting for somebody who's going to agree with you. Don't go from lawyer to lawyer. If a lawyer says to you, you don't have a case, why would you pursue it? You know, you're not going to go now to another lawyer with the same argument and say, do I have a case? The lawyer says, no. Okay, well, then he's obviously not a good lawyer. Listen to the professional advice that you're given. If you find a professional that you're going to work with, there is some, I mean, obviously you've got the power or the right to voice your concerns and to ask questions, and you must know what's going on all the time. You must feel like you're kept in the loop. But if something comes out that is pretty much standard procedure, just trust that the professional knows what they're doing and do not interfere with their advice, because once you do that, you're becoming your own worst enemy. Then you cause more trouble. I've got clients where I've had somebody's attorney say, I highly recommend that you don't do X. It is just going to cause trouble. And she didn't believe it, and she knew better, and she did X. And now she's in a situation that she actually doesn't know how to get out of. If she had just listened to the advice, she wouldn't have been in that situation at all. I have another client who received a letter from an attorney and sent it to me just to look at. I mean, now in my position, I cannot give legal advice. I cannot give psychological advice, anything like that. I mean, I'm not a lawyer, so there's definitely no ways I would. However, this letter said, do you agree with the following, X, Y, and Z? And X, Y, and Z was so standard and so normal. And this client was, I was coaching, so I wasn't a mediator, I wasn't a parenting coordinator. I was just helping this woman understand the process and helping her. And I said to her, okay, this is all normal standard practice. The child is acting out. We recommend psychological intervention. Yes, obviously we would. It would be a good idea for the child to be assessed. But because she was so angry with the ex-spouse, she sent a mail back saying, I don't agree with you, stop bullying me. And now we've got documentation of her completely going against what the attorney has said. She has now stated very clearly that she's not interested in what they have to say. And now they have decided that the only thing they can do is litigate, because now it's clear that she's not prepared to come to the party. And she can't understand that she has now done like severe damage to her case, you know. She doesn't realize that. If she had just kept a level head and listened to her lawyer and not gone behind their back to send an email to the opposing counsel, she'd be in a much better situation. So why do we do it? Because of fear, because we think we know better, and because of ego. Let's put all those things aside, listen to the process, and then we have got a much better shot. I mean, I can guarantee you that.
Daniella, you brought a very important point now about children acting out, and I see it on a regular basis, where kids play their parents. Honestly, they play their parents, and the parents spend thousands of rands and lawyers' letters and battles because the kids are playing one parent against the other parent, or tell the parent, one parent, Mommy, I do not want to go to daddy because daddy got a new girlfriend. But automatically, the child is playing the parents because the child does not like the new girlfriend. It's a decent lady in these facts. And the parents respond to it, they go to court, they spend a lot of money to litigate these type of issues because it's fueled by the minor children themselves. So I think with parenting plans and mediation, it's important for the parents to look, am I being rational? Am I being reasonable? Am I acting on emotion or on ego, etc.? On that point, Daniella, on our website, on our screen, those who are watching it via Facebook Live or live, www.ourlawyer.co.za/pp parenting plan. It's a parenting plan that they can download, drafted by you, standardized, template based. Obviously, you modify it and you change it as specifically required by the family or by the specific clients. Daniella, I hope that people will contact you soon here after this webinar. Many people are contacting me and telling me they love these videos, they like what Daniela is doing. On the issue concerning if parents cannot come to an agreement regarding a parenting plan, at which point do you refer them to court?
So from my side as a mediator, my process is to have a couple of sessions to see what the actual situation is. If we are in mediation and like nobody is willing to agree, what I usually then recommend as the next step is like a parenting evaluation. So what I do is I've got a family psychologist, clinical psychologist, forensic psychologist, who I refer a lot of clients to, who will then be in a situation where I say they are not agreeing, they won't do this. Our job is to make sure that the needs and the best interests of the children are met. So I need an assessment done now to see why we can't agree, to see the parenting capacities of both parents, and to interview the children to see what they want. And then we can make a more, let's call it, powerful recommendation. So you guys don't want to mediate, you clearly can't agree. Let's bring in the forensic assessment. And usually both parents are happy with that because they feel so strongly about their opinion that they feel that it will be verified by the professional. So they go and very often they do entertain this request of mine, let's call it. And then they have their whole thing, and then I get a recommendation saying it's in the best interest of the children to have 50-50 access to both parents. Fine, wonderful. We've now got like substantiative evidence that this is a good thing. So then we say, okay, now let's meet, let's give the feedback. It's been recommended by the professional that you have 50-50 access. Let's talk about that. No, still definitely not. At that point, then I would say, okay, well, we need to refer it to court because we've tried everything we can to make mediation a success. And even with a professional recommendation, you're still not prepared to change your point of view, then, I mean, that is obviously, it's never going to happen, you know. If couples do not want to go through a forensic assessment, then that's another juncture. So we'll have 3 or 4 sessions maybe. It's obvious that neither are prepared to negotiate here at all. I mean, at that point, we completely call mediation unsuccessful, and then at that point, we would have to refer it back to court.
Daniela, thank you for that. On the same note, with COVID-19 and the courts not much available to attend to court matters, you wait many months or quite a few weeks to get a date on the unopposed court roll at the High Court. Usually you just set the matter down 2-3 days from now. I would actually advise people, try to stay away from the courts for now at least, because you may wait an extremely long time to finalize your matter. In the sense of the kids are now 2 years old, it may only be finalized when the kids are 4 years old. Do you want to spend an entire 2 years of your life trying to resolve these type of matters in a litigation setting? And at the same time, the Office of the Family Advocate, they are extremely busy. There aren't many social workers available. I know they make use of yourself as well for assessments, but that's the reality. If you ask a family advocate now, I require the court asks them, I require an investigation, a report. The default time is, they mention, is 3 months, but I know for a fact it never gets done in 3 months' time. It's very rare when it does get done in 3 months' time. Unless the parties come to an agreement, it's maybe a quick consultation with the parties, they settle the matter, wonderful. But if it entails an investigation, appointing a social worker to provide a report, it can take many months, sometimes 6 months, a year, depending upon the circumstances. So a word of warning, yes, you need to go to court ultimately. There are many cases that merits going to court. But remember, the process is slow. The wheels of justice are moving much slower than they moved before March 2020.
Now, I've got two things to say to that. And I mean, obviously, everybody's personal situation is the biggest situation. Like, it is unfair to say that somebody else may need the court more than you do. I mean, it's unfair to say that. But let's bear in mind that when you come into fight because you want the child over Christmas, instead of having a child going to the wife over Christmas, like, that is taking up the court's time. And that is absolutely something that can be resolved privately, absolutely. We are now taking time away from kidnappings, from sexual abuse cases, from all of that kind of stuff to get our space on the roll. It's not really fair, And I am the kind of person, my whole mindset is, don't ever take power away from your situation because other people have it worse, because it's all relative. So something that is bad to you might be a cakewalk to somebody else. That doesn't mean that you are in a better situation, because in your life, relative to you, this is the worst case scenario. But realize that when something has a simple solution, or where something really is not going to be the end of the world in 5 years' time, let's try and think about the consequences of our actions. And I think that if I had it my way, if I could make any change with my magic wand, it would be that before anybody mediates, or before anyone goes to court at least, that they go through parenting classes and that they go through personal therapy. Because I can't tell you how many clients I have that are coaching through mediation, where they come to me and they say, I can't understand why the mediator is trying to make me give up my time on X. Where I can sit with that person and say, okay, well, let's unpack that. Why is this a problem for you? What does it do to you personally? Why does it feel like you're losing? Once we have the opportunity one-on-one with one of the parties to have a private team of psychological intervention or whatever it might be, they will 9 times out of 10 come back to the mediation situation much better prepared, with a much better understanding of their actual needs, and with a much better understanding of how their actions are affecting the children. Getting a person to go to such session is the trick here. It's very difficult. But if, like I said, if I had my magic wand, everyone who goes through mediation should have a therapist on their team to explain the situation to them and to explain how their actions are affecting the children. And like I said, that is an absolute game changer.
And Daniella, there's a reason why people study to become a therapist, to become a social worker, psychologist, psychiatrist, because there's a need for that. Society requires people like that to assist parties. A parenting coordinator, parenting class, co-parenting classes, etc. It's necessary. So do not feel bad that you go to these specific professionals for assistance. You shouldn't feel like it's a stigma on you, like we are not good enough parents. The same way, if you are ill, you go see a doctor. If you have legal problems, you go to after your will, you go to a lawyer. The same way, whatever the case may be, you go to a professional person. There's reasons why these people are in business, and they do lots of great work. And I think you need to consider these specific professional people to assist you in resolving your issues. If you have a psychological problem, stress, emotional issues, nothing to do with family law, you go to a psychologist, a counselor to assist you with that. Many people think we only go to people to deal with stuff you can see. Your car is broken, your mechanic, maybe accounting, or a lawyer require this and that. Things concerning psychology, the mind, abstract issues, they tend to move away from that. But it's important that they should know that there are professional people out there that have experience on these type of matters, years of experience, like yourself, Daniella. You know what you're talking about. That's where I'm going to.
I just want to quickly jump in there, because I think there is a big stigma still about mental health help. And I think what's important to realize is the difference between the different kinds of mental health providers. So a lot of people say, I mean, I've got family members who say, I'm not going to a psychologist, there's nothing wrong with me, okay? So the stigma is there, and it will always be there because nobody wants to acknowledge that they need help. So first and foremost, you've got a psychiatrist, and a psychiatrist is somebody who is available to administer medication for any mental disorders, right? So in this realm, when we're talking about parenting plans, mediators, all of that kind of stuff, a psychiatrist is definitely not somebody that we're looking to employ unless we've got a diagnosis of bipolar or schizophrenia or something like that. Okay, so psychiatrist, let's just take off the table for this discussion. Then we've got a clinical psychologist. And what a clinical psychologist does is they are there to diagnose the disorder. So they have therapy, they have psychology sessions with you where you pay them, you go tell them your problems, and they can say, yes, according to the DSM-5 table, which we work on, you are a candidate for depression, let's investigate that, right? So now I, as a clinical psychologist, can diagnose you with depression. I can then refer you to a psychiatrist to get you the right medication. Then we have got a counselor, right? And a counselor now is somebody that is not here to diagnose mental health disorders. We are not here to say that you've got problems with this and that. A counselor or a therapist is somebody who is literally here with the experience to help you navigate different problems that you might be facing. That might be something like, I don't want my husband to have my child because I don't like the way the ex-wife is trying to take my place as mom. Fine, that's something that I, as a therapist or as a counselor, can happily help you with. And then there should be no stigma because I'm just here to help you navigate that. I'm not here to tell you that you've got a mental illness, you know? You're not coming to me now to say that I feel like I'm hearing voices. That's not my job. And I find often that because I'm not a clinical psychologist. So I feel that people are less afraid to contact me because there is no stigma. There is not as much of a stigma. So you know what, when it comes to coaching, if you need a life coach, if you need somebody to help you organize your bedroom, whatever, find those people, they'll help you. They'll take so much stress off your shoulders. They'll help you live a more fulfilled life. And so what if you need help from one of these people? You know, it's not a weakness, you know, it will just help you.
Daniella, well said. And if I look at the example regarding seeing a psychiatrist directly, many people do not want to go to the dentist, for example. I'm using an example here because they're afraid they might have a problem with the teeth, or they do not want to go to check themselves out for, you know, cancer, whatever illness they may have, because there's a potential or possibility of being, you know, found positive for those specific illnesses, etc. So the same way we'll go to a psychiatrist, but a therapist is something else. You can actually speak to the therapist and tell the therapist, you know, I am afraid of going to this to do the following. What is your view? And the therapist can, you know, advise you and assist you. And sometimes, many times, Daniella, and this is very funny. I'm an advocate, so we charge for our time and consulting the client, etc. Many times, what the client requires is not necessarily legal advice. That could be part of it. They require somebody to listen to them, to you know, acknowledge and to advise them, you know, but basically to listen to them. And many of my consultations, the first consultation, it might be for an hour, but 30 minutes in that consultation, sometimes 40 minutes in that consultation, the client wants to speak to me about the problems they have, the issues they have, etc. Not necessarily want to know the legal aspect on how to deal with this. So they'll start bad mouthing the other party, saying how bad the other party is. I'll stop them and say, no, it's not necessary, let's go and deal with this topic. They'll come back on the topic. So most of the time it's about this letting go. But if they can let go with a professional person like yourself, who can maybe advise him, you know, that's not necessarily necessary. You know, his girlfriend of 10 years ago is his affair of 10 years ago, or when he ignited you guys 10 years ago, it's not necessary here. But speak to me about him a year, how you feel about it. So when they do meet with a professional like myself, an advocate, they will now just focus on what's necessary, and you can help them with that.
Exactly. There's a time and a place for everything. And like you say about the dentist, you're not going to go to the dentist if you've got a problem with your ear. Same way. You know what? Let's sort out my feelings. Go have the first consultation with the advocate. That's great. The advocate can then tell you what his role is. Then come and see a therapist to deal with everything that's outside of that. And then, I mean, then you're in a situation where you go back to the advocate and you pay for the time you need. You get the advice you need. You're not wasting anyone's time, you know. And I think, I don't know how to change the world. I don't know how to change the viewpoint. But if only we can do that, and if only we could make therapy a more standardized, like optional extra, then I think everybody would come off much better and much happier. And everybody would feel that the money they spend is worth it, and that the results are a direct result of their own action or desires or whatever, like or any of that kind of stuff. There's so many things that happen in our lives that we mix up or we avoid or we sweep under the rug or we blow out of proportion purely because we do not know how to deal with it internally. And we do not want to be accountable for anything, you know. I mean, that's just a human characteristic. That's not a flaw. That is how we're programmed. We don't want to be weak. We don't want to admit that we need help, and we do not want to be accountable. If we can unpack that and see that those things can actually be so powerful for us in ultimate self-actualization, we can realize that half of the stress that we have on our shoulders is completely irrelevant. And if we can just get rid of that, life would be so much easier and so much happier, guaranteed.
Yeah, and Daniella, many of the court cases which I deal with, not a lot of them, but there are a few of them, whereby the reason why one party may want to apply for primary care or have more contact rights is because the other parent is too stressed out. He's always stressed out. You can see she or he lives a life of a high stress. And the other parent feels, I need to intervene here because this parent is a bit too pedantic, she's too rigid, her ways aren't necessary, in the minor children's best interest of personality issues. It's unfortunate, that is a fact. And this causes one parent to approach me or approach the court, etc., to deal with this and maybe apply for 50-50 or apply for primary care. Sort out your mental well-being, I say well-being, with a professional person, and if that is resolved, the litigation or the process going forward is much, much easier. Daniella, on that point, we just passed the recording time of 46 minutes. I'm in it this close to 50 minutes. Any final words on your side? And this was very fruitful.
Not really. Just stick up for yourself. Don't worry about anyone else's opinions, other than your professionals, of course. And if you need help, take the help. There's so many people here wanting to give, like desperately wanting to give the help. So take it and use it, and that's it.
Thank you for that, Daniella. Just to recap today's webinar, Daniella and my view on this matter is when you separate from the other party, try to enter into a parenting plan as soon as possible. Have something in writing, see a professional person. Remember, you never ever experienced separation before the time. You never had a child where the parties are separated before, so you need to get a professional that can advise you. The same way, if a party has a certain medical problem, you never had it before, you go to a doctor advises you and assists you going forward. So that's where people like Daniella and of course many legal practitioners come in and assist you in the separation and the parenting of the minor child post the separation. Remember, the child had one household first, mom and dad in the same household, or they were in a relationship. Now there's two households, two lives, everything is different now, and we need to have a parenting plan in place. Daniella, thank you for your time. On the screen, your details, Daniella Mair, your website, your email address and your telephone number. I know you're very approachable via WhatsApp. Is that still the case?
Yes, sir.
Okay, wonderful.
Definitely.
Wonderful. Daniella, stay on the line. Stay on the Zoom line. I'll just end it off on the Facebook Live and we'll chat a bit further. But thank you for all the viewers and the listeners. I hope you have a wonderful day and we'll see you online very, very soon.
Thank you.